Shoot me an email. I just missed it. Yeah, shoot me an email. No. I bet you did. If you hadn't answered, I would have given you a 0. So sometimes when I'm doing the rubric, I skip stuff. And so thank you for noticing that.
Okay, I'll email you about it.
Okay, perfect.
Watch my grade go down from it.
No,
I'll be like, oh my gosh.
no, it can only add because right now it's like 0 points for that. So
Okay.
as long as you did something, you'll get at least 1 point. Alrighty, well, we'll go ahead and get started. Our giant class. Thank you for being here, and thanks to the folks on Zoom for being here. Folks on Zoom, there's only 3 people in person right now, so not really sure what's going on today. I know some people have sporting events. The softball team is traveling, for example. But who's to say we can't have an awesome class with just the 6 of us? So we will do that. Alrighty. Welcome. Alrighty, so when we were talking last week, we had just we were about to start talking about the workman's comp version of evals, and I was like, that's gonna take us too long, so I wanted to give us enough time to do it all in one lecture. So this is related to liability evals, but in this case, you're looking particularly at folks who were hurt on the job and file for damages based off of that. Typically when they are filing for this, it's not just psychological, there's often a physical injury as well, but certainly psychological can be a piece of it. And interestingly, workman's comp is not a judicial proceeding. Instead, there's like an administrative judge who's typically appointed by a governor of the state. And it can be appealed to higher levels of the workman's comp administration or workers' comp. I've heard it said both ways. And you do the same types of assessments we talked about last week in terms of what you do to look for personal injury. The Workers' Comp Bureau doesn't have enough psychologists to do the evaluations, so they usually contract out with psychologists. Also, if a worker is dissatisfied with the evaluation provided, they can get an independent evaluation. However, just like with other types of court cases we've talked about, the person in front of you is not your client. It is the Workers' Comp Bureau that becomes your client in these scenarios. So it is the agency you're going to give that report to, rather than who we have at that point in time. Hello, folks who are joining on Zoom. Just checking you off. Feeling a little better, not having only 6 people here. All right. So they usually as a psychologist, you don't get a lot of money for doing these evaluations. In court cases, you're much more likely to get a lot of money because it's like got rich people with rich lawyers. So folks who do these are sort of like a side hustle, things along those lines. If workers are compensated, so if based on your eval and everything else that's brought up during the case, the size of the award they receive is determined by a couple things. One is the type and duration of the injury. And then the other thing is their salary at the time of the injury. So essentially, workers' comp is to make up for lost wages. And workers can seek compensation for physical and psychological injuries suffered at work, the cost of whatever treatment they go through, lost wages, and then the one that's really important is the loss of future earning capacity. So if this person is in a point where now they cannot do the job they were doing, they can essentially say, you should compensate me for the fact that like I can't work the next 20 years, things along those lines. So psychologists in this type of eval are often asked to render an opinion about the existence, cause, and implications of any mental disorder. And so claims for mental disability typically arise in one of these two ways. So physical mental cases is where a physical injury can lead to a mental disorder and psychological disability. Mental cases is where perhaps an individual has suffered a traumatic incident at work that leads to substantial psychological difficulties. So mental is like directly from what happened at work, you have psychological consequences. Physical mental would be because of the physical damages you suffered at work, you now have psychological issues, perhaps depression, anxiety, something along those lines. In recent years, there's been a surge in these mental cases. Why? Some people argue it's because more women are now part of the workforce. Women are more often diagnosed with anxiety and depression disorders. We also know that unfortunately women are more likely to be the targets of any kind of sexual harassment. Perhaps due to a shift in the job market from manufacturing and industrial jobs to more service-oriented jobs. And so this means that you would have more interpersonal stressors and maybe less physical stressors. So a heavy piece of equipment is less likely to fall on you. But anyone that's ever worked in a customer service related job, whether that's as in a restaurant, as a cashier, what have you, knows you get screamed at a lot, right? It's great. So that can build up. And some people argue that it's perhaps motivated by financial incentives. So those can come up as well. So similar to any other personal injury case, you would do a full assessment, think about how much this is affecting them, think about if it's a change from sort of pre-accident, level of functioning. All right, the next one we're going to start talking about is civil competence. And the question of civil competence focuses on whether an individual has the capacity to understand information that is relevant to decision-making in a given situation. I'll say that again because it's kind of wordy. So whether an individual has the capacity to understand information that's relevant to decision-making in a particular situation. And then using that information, do they have the capacity to make an informed choice about what to do in the situation? So this would be, of various questions that come up, like, is this person competent to manage their own financial affairs? Can one make competent decisions about medical or psychiatric treatment? Is this person competent to execute a will and decide how to distribute property? This becomes a question, especially when people change their wills towards the end of their life. People will try to argue, oh, they were incompetent to do that. So when this happens, typically people will have like a doctor, a psychiatrist sign off that like, no, they were competent when they made these changes. Can they make advanced decisions about their medical treatment if they're terminally ill or seriously injured? So things like advanced medical directives, DNRs, do not resuscitate, things along those lines. A competent individual is expected to be able to understand basic information that's relevant to making a decision, apply that information to the specific situation in order to anticipate the consequences of making various choices. So let's use the will, for example. Let's say you have finally figured out very late in your life that one of your children is an absolutely horrible person, right? They've been treating you horribly. Maybe they've been like abusing their children, right? You need to understand the consequence of you not including them in your will is that, they'll probably be mad, but they also won't have the financial means to sort of ratchet that up, right? You also need to be able to use logical or rational thinking to evaluate pros and cons of various strategies and decisions, and be able to communicate your personal decision or choice. And this doesn't have to be oral, right? If the person has lost their capacity to speak, say through a stroke or something along those lines, if you can communicate by writing, that is considered acceptable as well. The question of competence to consent to treatment can arise when one refuses treatment that seems to be justified. So this is usually families that want their loved one to keep living, that will sort of fight against this. So what the medical professionals will try to do is simplify the information so that it's clearer for them to understand. And if that doesn't help, you could actually administer a clinical competence instrument, like the MacArthur Competence Assessment Tool for treatment decisions. MacArthur dishing those out, making the money for all these assessment tools, to determine whether the patient lacks the necessary ability to reach a competent decision. Psychologists can evaluate whether a person called a testator was competent to execute a will. Such competent is a requirement for the will to be valid. So evaluations for these will include a determination of the purpose of the will and why it's written at this time, information about the property holdings, insight into the family dynamics, and an assessment of the general consequences of the dispositions of the will. So the other place we can get involved is in employment discrimination and harassment cases. So brief introduction here. people tend to think of sexual or gender-based discrimination, but you can be discriminated unfortunately in a whole host of different ways. For example, age discrimination, discrimination based on disability, race, things along those lines. So Title VII of the Civil Rights Acts is the work equivalent to Title IX in terms of non-discrimination. So Title VII says that you cannot make an employment decision on the basis of race, sex, color, religion, or national origin. Now, if you notice, that's missing some stuff, right? It doesn't have things like gender identity. It doesn't have things like sexual orientation. This was written, I believe, in the 70s. So those issues weren't being thought of in the same way they are today. Then there's the Equal Employment Opportunities Act. This act established the Equal Employment Opportunity Commission, which you may have heard of as the EEOC. This tends to oversee a lot of these discrimination cases. There's also the Age Discrimination and Employment Act that extends to older adults. So what we tend to look at here are what are called protected classes of people. And these protected classes are people we know that tend to be discriminated against, people that are often minoritized, right, and discriminated because of that. And what you're going to look at are the discrimination effects. And this is looking at groups or classes of people. And psychologists here would testify as an expert witness about research findings related to, in general, when this group of people is discriminated against, this is what happens. So, for example, one of the more famous studies in psychology history was done by Mimi Phipps Clark and her husband Kenneth Clark. And they showed white kids and black kids, white and black dolls. And when they asked the black children, point to the one that's pretty, point to the one that's smart, they were always pointing to the white doll. And so they used this and wrote an amicus brief in the Brown versus Board of Education Supreme Court case. And this was heavily relied on in the Supreme Court making the decision that separate education was not equal, and this was negatively affecting the children. So there's a prime example of this type of testimony. And then they also can look at discrimination treatment. And this is where you look at the effects on that particular individual. And this is where people will claim damages because of discrimination, very similar to workers' comp we just talked about, right? So lost wages, lost promotion, things like that. And psychologists here would do individual evaluations, or they could also testify similar to discrimination effects about the overall negative effects of discrimination. So the sequence here, claims of discrimination have to be handled at the employer level first. Typically, you tell someone within the company if you feel safe and comfortable doing so. This gets more and more problematic depending on how small the company is, depending on who is HR, right? Is HR the person abusing you or discriminating against you, right? A lot of larger companies will have an Office of Affirmative Action, or will have some sort of office that's specifically for reporting these types of incidents. So they'll receive complaints about all types of inappropriate and discriminatory behavior. One of the issues that arises, of course, is that because we want this to be a fair and just process, the person who is the person doing the discrimination has a right to know who is complaining about them. Then what we fear is what's called retaliation, where that person who is being complained against will lash out in some way. It's the complainant. So typically companies will try to get an informal resolution and just sort of work it out between folks. They're not always good at doing this. So for example, I know of a case where a female worker made a flippant comment about how difficult it was to be, a white man, because this guy was sort of whining, and he went to HR and filed a complaint against her for racial discrimination. She was also white. And so, HR was like, you need to go to communications class to the woman. And she was like, absolutely not. So, good for her, right? Sometimes people don't know quite how to handle these things. So then it can get elevated into a formal inquiry. And this is typically the EEOC, an administrative body, where they have investigators and hearing officers. And if you are the complainant, the one who's saying, I was discriminated against, you're usually asked to indicate what remedy you want. Do you want the promotion you were passed over for? Do you want monetary compensation? If it can't be resolved there, then it goes to the judicial system. And in particular, these tend to go through federal court. So what is the responsibility of an employer? How can essentially an employer avoid having to go through one of these? Employers have a duty to provide a workplace free from hostility, intimidation, or insult. If clear, tangible effects of discrimination are evident, for example, this person has been denied a promotion when they were qualified, then the employer is liable, and this goes all the way up to the head of the company, even if the head of the company didn't know what was going on at the lower ranks. So let's say Fortune 500 company, we're down and like someone's supposed to get promoted to like an assistant supervisor and doesn't. The CEO is, and the company as a whole is still held responsible, even if they weren't implicated in that, because the idea is you should have trained your lower level people enough to know that's discriminatory. In the absence of physical damages or evidence, and you might think, like, how could there be physical things? Unfortunately, people have suffered physical attacks at work, particularly due to racial or sexual orientation discrimination. There's a history of particularly female workers in male-dominated jobs like mining being sexually assaulted on the job. But typically you don't see that, right? Typically it's words. Then what we talk about is a hostile work environment. In that situation, the plaintiff needs to show that the employer knew what was going on and didn't do anything about it. So the hostile work environment, particularly for sexual harassment, but certainly this can apply to other types of harassment, is one that interferes with your work performance and seriously affected the individual's psychological well-being. The Supreme Court has ruled it's enough to affect the person's job performance. You don't need to have also like a denied promotion. And this is generally what's claimed when no tangible effects are evident. And this can include a whole host of things: jokes, comments about the way people dress, comments about their appearance. Many years back, I had like the head of HR come to one of my classes and talk about this, and not cases from here, but she found cases in the state of Virginia. One was a place where the male employees had calendars with naked women posted all over the office, right? That can be a hostile work environment. Another was a kissing club where they made all the women kiss the boss. Problematic, right? There's not necessarily clear and compelling standards here. Sometimes the court has said it's harassment if it's offensive to you, even if no one else is offended by it. And then sometimes the court will say you need to compare to sort of like the average person and would they be offended. The penalties and consequences for this, when it finally goes through the ranks, unfortunately, often companies will try to like squash these, right? But when these go through the ranks, and particularly if they go to court, the penalties and consequences are often extreme. So workplaces will try to create environments without opportunities for people to be offended. So employers will put protections in place, having sensitivity training. I don't know if you all have to do this or just employees of the university, but every year we have to do a Title IX training, for example. Other things, recognizing that the employer is actively doing something. Having an office specifically designed and dedicating to handling those complaints, whether that's HR, whether they have their own Office of Affirmative Action. If an employee reports to the higher ups that they have been harassed or discriminated against, and it's not followed up on, that in and of itself is a problem. So if you report and they don't do any sort of follow-up, that in and of itself is illegal. So how do psychologists get involved in these types of cases? So in the general level, as we mentioned previously, they can be called in on expert witnesses on the effects of harassment and discrimination on people in general. They can also be asked to assess a particular individual and testify. And in some cases, they will ask you to do both, which is weird because in criminal cases, you wouldn't do both, but here it's a little more flexible. So what issues arise in assessments and in cases in general? Well, one is, did the alleged events occur? This is the first thing the hearing body has to decide. This is not the psychologist's decision. If it did not occur or there's no evidence, there's no action, the case is dropped. If it did occur, then they talk about welcomeness. There we go. I was like, I know I have a slide about this. All right, so welcomeness is, were you a victim or were you a participant? This becomes pretty tricky to sort out, right? Because some people will laugh along with jokes because they're afraid not to, right? Things along those lines. So now what you're assessing are people's internal feelings, motivations, and fears. And if you can't demonstrate that it was unwelcome, then again, the case is typically dropped, and psychologists will get involved in assessment here. Where psychologists definitely get involved is the effects of the events. So psychologists will look at things like, did that person's job performance suffer because of the discrimination or harassment they experienced? And the EEOC can address this. So for example, loss of money due to not getting a promotion. And then general personal emotional effects. So is this person experiencing anxiety, depression as a result of it? So compensation for psychological damages, that would be addressed in court. And then another thing you have to address is the time frame. You have to establish cause and effect, again, kind of similar to personal injury. The eggshell idea applies here, that vulnerability does not excuse the behavior of others that aggravated previous conditions. So if this person was already someone who was very anxious, that doesn't mean they can't ask for damages for harassment that made them even more anxious. You also, as a psychologist, are trying to project change. So how long lasting will the effects of this be? And what does this person need to be able to sort of be a functioning human being? In terms of the process, this is no different than other types of evals we've talked about. The sources of data that you want to try to get are to interview everyone who is relevant to the case. So the complainant, the plaintiff, the supposed harasser, other witnesses, friends, family, etc. You want to do observation during the interview. I mean, most psychologists are not trained in micro expressions, right? But you still want to look at body language and try to get an idea in terms of like, are they telling the truth or not? You look at records, so job performance, previous therapy records, and then psychological tests of current functioning. The limitation here is we typically don't have a baseline unless this person had somehow been evaluated previously psychologically. But if the person is showing current distress, this is really helpful in their case. So you do have to assess for malingering as well. How valid is their distress, their maladjustment? It can be hard to parse out their approach to the test here then. I mean, some people who have been harassed want to see themselves more with the survivor label, right? And this hasn't affected me, but I want to do something about it. Whereas other people will be more open about the psychological consequences. And I think I have, for whatever reason, these notes a couple slides back. So psychologists usually only get involved if it goes to federal court. And they can get involved in treatment of the person either during or after the harassment. However, typically you don't want to then be the person that assesses that person just so you can claim objectivity. All right, so what about disability discrimination? Well, the Americans with Disabilities Act from 1990 prevents employers from discrimination based on disability. It's intended for once you're in the workplace. So unfortunately, it's not hiring, it's not being promoted, or not firing people. What it is are making sure you have certain accommodations like wheelchair ramps, parking spaces for wheelchair access, access for people who are physically disabled to things like restrooms, elevators. Now, the interesting thing about this is that places can get sort of grandfathered out of some of this. So who in here has had classes over the second level of Village 1 over here? Yeah, no elevator, right? One summer we used to have a different system for summer advising. And I was a summer advisor and they would give us student assistants. My student assistant was in a wheelchair and they put us on the second floor over there. It was like the most embarrassed I've ever been in terms of Wesleyan's inclusivity. I mean, luckily someone just switched with us, but it was super awkward. Yeah, and because it's like, if buildings are built before a certain time, they're not required by law to update them. And it's hilarious to me that ours are like historical buildings. I'm sorry. I went to a college that was founded in the 1850s. So like the idea that like these are treasured sacred buildings we don't want to put an elevator in is a little funny to me. That's just my own cynicism. But yeah, so like you don't have to spend the money if that's the case. And so, but then the idea is you make reasonable accommodations, right? So for that particular student, if she'd had a class put there, the teacher would have to move the class so that she could access it. Complaints for any discrimination based on disability go to the EEOC as well. And if you don't like the decision the EEOC makes, then you can appeal to federal court. So physical and mental disabilities are both covered, but just having a disorder or an injury is not enough. You need to show impairment, that this is adversely affecting one or more major life activities. And that needs to be documented, including the severity and the duration. There are some disorders that are excluded that are largely psychological. So sexual disorders and dysfunctions are not included. If you're a pedophile, we do not have to accommodate you. Fair, right? Impulse disorder or disorders like compulsive gambling, kleptomania, pyromania, we don't have to let you steal from work, right? Psychoactive substance abuse of illegal drugs, not included. But if the person is rehabilitated, that is covered. You cannot discriminate against someone who is not actively using, who was a user in the past. And then why is homosexuality on here, Dr. Myers? Because up until the 70s, unfortunately, homosexuality was classified as a sexual disorder in the DSM. What a proud history we have in psychology. And so they were included as non-discrimination back then as sort of a excluded disorder, but now based on modern laws, they are covered separately by the EEOC. So that's something at least. It also doesn't include personality disorders. These were originally not listed in the ADA. The EEOC, though, later did say, okay, we can include personality disorders as something you cannot discriminate against someone for having. So in order to sort of make a claim that you've been discriminated against, you need to inform your employer of your disability and have record and verification of it. So in terms of discrimination, what you have to show is that there's differential treatment for people with disabilities and without disabilities. Part of this is that the criteria for hiring someone or maintaining a job has to be relevant to the job itself. You need to show it's relevant. So for example, there are a lot of employers who will try to get around the ADA by saying you need to be able to pick up 50 pounds. And it's like, I'm going to be working an office job. Do I really need to be able to pick up 50 pounds? Right? And so the employer would be obligated, if anyone questioned that, to show that's relevant. Essentially, can you do the job with your disability? There are exceptions here. So if public safety would be at risk for something because someone couldn't physically do something, then there are very high standards. If you can do the job of what they call reasonable accommodation, then the employer is required to retain you. However, the ADA is silent on in terms of like how the employer has to shoulder the expense. The EEOC and the courts would decide this for each case, basically. It's not clearly defined, unfortunately, what reasonable accommodation is. And the really interesting thing is that employers don't have to anticipate reasonable accommodation, but they do have to respond if they have an employee with a disability. So this often ends up going to federal court to get it settled, and it's usually very demanding of employers. So for example, if we thought about, Village One, it would be like, okay, Wesleyan, you got to pony up the money so that you can put an elevator down. In terms of accommodation of mental disorders, typically you have to, within your health insurance, provide treatment. This is actually one of the reasons many companies now partner with or even have within their building what's called an employee assistance program, or EAP. And this is typically a limited number of sessions, say 6, that you get free of charge, don't have to use your insurance to address psychological issues. And the person has to meet the job requirements with the accommodation. So where do psychologists get involved? Sometimes during the hiring process, as we previously talked about, we're doing the assessments for folks for police, EMT, firefighters, nuclear power plants, airline pilots, air traffic control. I didn't get to do this, Val, but one of my friends did. She did a recertification for somebody who was an air traffic controller, and then she had to do a neuropsychological assessment to make sure they were sort of able cognitively to handle the tasks. And it was very interesting. She sort of shared with us everything they had to go through and how carefully controlled the environment is for air traffic controllers. They have a very important job, obviously. So these will require psych evaluations as part of the hiring process. And as I mentioned previously, typically they offer the person conditional employment. And the employer does a screening based on anything but the psych eval. They take the most qualified folks, offer conditional employment, give them the psych eval, and basically say, if anything pops up, we can terminate your employment. So the psychologist is going to test and determine if there's a mental disorder present, and if so, would that interfere with the person's ability to do this job? This also comes into play during those fitness for duty or return to work evaluations we talked about. Psychologists also may be involved in hostile work environment queries for discrimination based on disability, same as any other type of discrimination. And they may do evaluations. They have to be familiar with the standards and procedures. And these would then be similar to other discrimination evaluations in terms of what has been the psychological impact of the discrimination. But they can also be asked to serve as expert witnesses to talk about these issues. All right, the other fun thing that clinicians may be called on is to give an opinion about a deceased person's state of mind as it existed a specific time before death. And so these types of evaluations are termed psychological autopsies. And these rely mostly on information from two particular sources. The first is interviews with third parties who knew the deceased. So family members, friends, and co-workers, that type of thing. And then also prior records. The reliability of these, we don't know, was the funny thing, because typically when we test reliability, we test it against like the gold standard of actually talking to the person, and you can't do that. The reliability is probably low, to be honest, because you are dependent on other people's perceptions of that person, right? And as we all know, people can really hide what they're actually thinking, feeling. I think of the example of, I think it was back in either December or January, Twitch Box, who was a well-known dancer on So You Think You Can Dance, seemed like the happiest guy in the world, and he died by suicide, right? And even people close to him were like, I am shocked, I never got an indication of this, right? So people can hide stuff from those closest to them. How have testimony about psychological autopsies fared in court? And cases involving workers' comp claims and questions of whether insurance benefits should be paid, the courts have usually admitted psychological autopsy information. In criminal cases, or in cases involving the question of whether the person had a mental capacity to execute a will, the courts have been more reluctant to accept this particular type of testimony. So, can we do it? Kind of. Can we do it well? Probably not. All right, so then we can talk about civil commitment and risk assessment. So some of this dialogue will be similar to what we talked about when we talked about criminal commitment. So all 50 states and DC have civil commitment laws. And these laws authorize the custody and restraint of persons who, as a result of mental illness, are a danger to themselves or others, or who are so gravely disabled by their mental illness that they cannot care for themselves. And there are 4 types of commitment procedures. So emergency detention is the most common way that individuals are initially admitted to hospitals. So this would be typically danger to self or others. We're going to put you in here either for your own safety, the safety of the public, or both. There's voluntary inpatient commitment, where the person says, I know that I need long-term care, put me in here. Involuntary inpatient commitment. So this would be beyond a temporary hold. Most places have like 72-hour holds, right? That would be emergency detention. Inpatient voluntary or involuntary commitment would be longer, and that requires a court order. You can't just do it. You can also do what's called outpatient commitment, and this is where you would say the person has to go to outpatient therapy. So part of this is going to be a risk assessment and an assessment of dangerousness. The terms dangerous and dangerousness merge three distinct constructs. One is risk factors. Risk factors are variables associated with the probability that violence or aggression will occur. The second is harm, the nature and severity of predicted and or actual aggression. And the third is risk level, which is the probability that harm will occur. Clinicians who perform risk assessments try to predict which people are and are not likely to behave violently in certain circumstances. They also try to give some estimate of the risk for violence and then offer suggestions on how to reduce that risk. Many factors, as you can imagine, make risk assessment quite difficult. So some of the reasons is the base rate of violence in some groups is low. So clinicians are being asked to predict a phenomenon that rarely occurs. And we know whenever we do that, whether it's people or cars, we're really bad at it because we just don't have enough data to make a good model. Predictions have often been for long-term risk, which is harder to predict than violence risk over a shorter time frame. So in order to be accurate, clinicians should have information about a range of historical, personal, and environmental violence-related variables. Again, as we've talked about previously, the best predictor of future behavior is going to be present or past behavior. Do they have a history of run-ins with the laws, assault and battery, that type of thing? Or if we're talking about danger to themselves, do they have a history of past suicide attempts? Clinicians should also have limitations on the predictions for specific types of violent behavior, right? We should be honest about our ability to predict things accurately or lack thereof. And then concentrate on appraising risks based on specific settings rather than risk in general. So if I put this, say this person can go back to their home, what is the likelihood they will be violent there or try to harm themselves there? All right, we got through this a lot more quickly than I thought we would. So we'll go ahead and end class a half hour early today. Give you all a little breathing room. I'm just gonna see if I missed anybody who signed on later. And on Thursday, we'll start talking about jury selection, which is a really interesting way that psychologists get involved in the legal system as well.